The threshold for fraud is you have to show through clear and convincing evidence that they knew that they were defrauding you. So that's a really high threshold. For most like lemon law and breach of warranty claims, you just have to show through what's called the preponderance of the evidence, which means if you had two scales, right, one for the defense, one for the plaintiff, the scales just sort of have to tip in one side or the other. So wherever you think most likely is the one, telling the truth or who's right in this situation, they're the ones that need to be successful. Hi, I'm Emma.
And I'm Courtney.
And this is Lemon Law Unpeeled, the Lemon Law podcast. Today, we're going to be discussing used cars and lemon law and how lemon law applies if you purchase a used vehicle that's having issues, along with breach of warranty or the Magnuson-Moss Warranty Act, and how that may change or apply if you have a vehicle that you purchased and you are not the first owner. So the simplest one for used cars is breach of warranty, right? The Magnuson-Moss Warranty Act is pretty straightforward and applies to new or used vehicles. It really doesn't quite matter, but I will let Courtney talk about that and what the requirements are and how used vehicles are able to have coverage under breach of warranty if you're having issues.
Yeah, so generally, Emma, used cars will not qualify under the lemon law with a few specific exceptions, which we will get into. But what used cars do qualify under is the Magnuson-Moss Breach of Warranty Act. So under Magnuson-Moss, it does not matter actually if a vehicle is new or used. All we have to do is show that a vehicle had a warrantable issue, so a defect that was covered under the manufacturer's warranty that occurred within the warranty period that could not be resolved in a reasonable number of attempts. And it does not matter if you were the first or the fifth owner of the vehicle, as long as this issue occurred within that manufacturer's warranty period.
Breach of warranty is just like it sounds, right? It just deals with warranties. You just have to have the original factory warranty still in play on the vehicle in order to qualify. And to kind of explain that a little bit more, when we say the factory warranty needs to be in play, we just mean the problem has to start under the original factory warranty for you to have coverage. Now, when dealing with used vehicles under breach of warranty, where it can get tricky is the statute of limitations. So some states like New York, Maryland, Georgia, they have very strict statutes of limitations for bringing a breach of warranty claim that actually start from when the first person bought the vehicle, not necessarily when you bought it. Generally, it's about 4 years from the original date of purchase. But Courtney, I'm sure you've had it too, where clients call in and they're like, oh, but I've only had the vehicle for a year. I've only had it for X amount of time. Why can't I still bring a claim?
Yeah, we hear that all the time. And even with the warranty or the mileage requirements under lemon law, people often think, all right, well, it has to occur within the first 12,000 or 18 or 24,000 miles. And they don't realize that that's the mileage on the vehicle's life, starting from when the vehicle was first put into play by any owner, not necessarily by themselves.
Right. So when we get a call for a client that has a 2020 vehicle that they purchased in New York, but they're the second or third owner, it doesn't really matter where you fall in terms of if you're the second owner or third owner. You just need to have the factory warranty in play. And we always will pull a Carfax report or something of the like so we can see the original in-service date so we know how much time we have or don't have to be able to bring a claim, because the statute of limitations is the amount of time you have to bring a case. And once that expires, unfortunately, there's nothing more that you can do, which a lot of clients, and it's not unwarranted, they don't think that's fair, because if you think about it, a lot of factory warranties run longer than 4 years. So what am I supposed to do if it happens in the fifth year and I have an issue? And that's sort of the tough part. These certain states have not really made exceptions to that or carved out any sort of ways to deal with that issue. They've just sort of cut it off at the knees, especially New York, and just been like, nope, it's 4 years and that's it. Which, I'm not sure I quite agree with, because like we talked about, even Kia has a 10-year, 100,000 mile warranty. So then where does that leave you?
Yeah, exactly. It would leave you in the place where you are covered under the warranty and you can continue to get your vehicle serviced free of charge, but you wouldn't have any recourse if they're not fixing that issue. You wouldn't be able to bring a lemon law or breach of warranty claim. And it seems unfair, But unfortunately, our hands are tied by the law and we just have to work within them. And there's not a whole lot we can do if you're past the statute of limitations.
Right. And there are some states where there's flex, right? Pennsylvania, New Jersey, Maine, Colorado, their statute of limitations have a little bit of flexibility in them. In either, Pennsylvania and Maine and Colorado, I believe, basically say it starts from when the breach occurred. So whenever it's determined that the warranty was breached, then the statute of limitation starts. There's some flexibility there in how that could be interpreted. And Courtney, I'll let you talk about in New Jersey, the repair doctrine that they have that also can be used to kind of push that statute of limitations out to give us more time to bring a case.
Yeah, it essentially tolls the statute of limitations to when you knew or should have known of the breach, meaning when did I know or should I have known that that issue was not going to be able to be repaired in a reasonable number of attempts? Well, was it after the third time they repaired it? Was it after the fifth time they repaired it? So you can kind of keep pushing it back and back and back. It's hard for the court to say, well, you should have brought the claim within the first 3 years, because you might say, well, they had fixed it. They fixed it for the fourth time. They told me it was good to go. They told me they replaced the whole part that needed to be replaced, and everything was good to go. And you had no reason to believe that it wasn't going to be good to go and that issue was going to recur. So you can kind of keep pushing back that statute of limitations every time that issue occurs.
Right. There's some nice flexibility there that we will absolutely use, if we can. Where things get even trickier is, so a very limited number of states have what's called a used car lemon law. So most lemon laws apply only to new vehicles, right? So vehicles brought brand new. There are other lemon laws like New Jersey's that doesn't quite say that it has to be new. You just have to have had multiple visits or multiple days out of service within the initial 2 years or 24,000 miles. But Courtney, I'll let you talk a little bit about how lemon law, even though it applies to used vehicles in New Jersey, it can get a little tricky.
Yeah, it can. So a lot of times people will say, well, I read that there is a used car lemon law. But unfortunately, the used car lemon law doesn't work quite the same way as the regular or the new car lemon law. Used car lemon law is actually backed by the dealership, not by the manufacturer. So it's only going to cover an issue that was covered by a dealership warranty, not by the manufacturer's original warranty, which is what 100% of people have. Some people do then also have dealership warranties that they may have purchased on top of that original manufacturer's warranty that came with the vehicle. But if your issue is being covered under the manufacturer's warranty, that's not something that you're going to be able to bring a claim for under the used vehicle lemon law. So it's very, very narrow when you can bring a used car lemon law claim. It has to be a very specific situation and a very specific defect and being covered in a specific way.
Right. So to break it down even further, so New York and New Jersey are two good examples of states that have both a new car lemon law and a used car lemon law. So, and both of the new car lemon laws are a little bit of a misnomer because New York and New Jersey don't require that your vehicle actually be purchased new to qualify under the new car lemon law. You just have to have your multiple visits or days out of service within the designated time period. So for New York, that would be the initial 2 years or 18,000 miles of the vehicle's life. New Jersey would be the initial 2 years, 24,000 miles. So let's say you're in New York, you buy a vehicle that's 1 year old, it has 10,000 miles on it. You technically could still have a new car lemon law claim in New York because you're within the requisite time period, even though you're the second owner. It can be a little bit more difficult to get the actual buyback, though, when a vehicle is used and trying to push it under the new car lemon law, but it's absolutely a possibility, and you still have all of those rights there. Where things can get tricky is when you purchase a used vehicle, right? And your used vehicle is still under the original factory warranty. Because like Courtney said, the used car lemon law in both New York and New Jersey only applies to dealerships. So dealerships in New Jersey and New York, no matter what, have to give a used car lemon law warranty with these vehicles. There are certain limitations. So for example, in New Jersey, the vehicle has to be like less than 7 years old and have less than 100,000 miles on it to qualify under the used car lemon law. And in both New Jersey and New York, once your vehicle hits, I think, more than 60,000 miles, you can sign away your used car lemon law rights. It's just anytime prior to that, the dealership still has to give you that lemon law warranty. And additionally, both New York and New Jersey outline the bare bones of what that warranty has to include, right, at a minimum. So the dealership can choose to add more coverage if they so choose, but the laws basically just say, hey, you have to at least cover X, Y, and Z. So not only with these used car lemon laws do you have to fit within a certain mileage and time frame, but you also have to have certain components breaking down. So for example, your engine is something that would be required to be covered under New York lemon law. But if you're having an issue outside of that, that doesn't necessarily fall within those specific minimums that they put on there, then you're not covered, right? Because it still has to be what's considered a substantial impairment. Additionally, both New York and New Jersey's lemon law, both New York and New Jersey's used car lemon law breaks down when your problem has to arise. So similar to the new car lemon law, where you have to have your visits within a certain amount of time, or you have to have your days out of service within a specific period of time, the used car lemon law in both New York and New Jersey function very similarly, in that depending on the amount of miles on the vehicle at the time of purchase, you only have a certain number of months to be able to bring your vehicle in for repair. So it goes from 30 to 60 to 90, right? With the lowest mileage, you've got 90 days to have your multiple visits or days out of service. And then depending on which category you fall in terms of how many miles are on the car, it can change, like I said, from 90 to 60 to 30. So let's say you buy a vehicle with 70,000 miles on it. You did sign away your used car lemon law rights. You still have it, but your problem started 4 months after purchase. You wouldn't have a claim because there's very specific parameters as to when the problem has to start and when you have your visits to be able to bring a claim against the dealership. And as Courtney pointed out, let's say you purchase a vehicle with, 40,000 miles on it, right? It's used, and you start having engine issues, and you're still covered under your, we'll say, Chrysler 5-year, 60,000 mile factory warranty. So even if you have a substantial defect, you were back to the dealership within the requisite time period for the used car lemon law. You've had 3 or more visits for the issue and it's still ongoing and it is severe. If that defect is being covered under the Chrysler original factory warranty, you unfortunately don't have a used car lemon law claim. You can only bring a claim against Dodge for breach of warranty, which is tough, right, Courtney? Because the difference between your remedy under a used car lemon law and breach of warranty are very different.
Yeah, that's right. Under a used car lemon law, you're obviously looking at more of a lemon law standard, which, as we've talked about in the past, is you can get a repurchase or replacement of the vehicle. You can get your money back. Under breach of warranty, you can get a percentage of your money back and you keep the vehicle. But when you're looking at a vehicle that you no longer want, and maybe you're upside down in a loan, or it's going to cost you a ton of money to trade out, there's a ton of natural depreciation, for whatever reason, it's not going to be feasible for you to trade out of this vehicle. Well, $3,000, $4,000, $6,000, $7,000 might not do a whole lot for you. And so they're vastly different remedies.
It's tough. So I remember I had an attorney in New York call me because he had a client of his that it was a Dodge that was having issues. And so he explained all of it to me and I felt badly because it was like severe transmission issues. The car was just totally failing. And unfortunately, at the end of the call, I had to tell him that there was nothing that we could do. So the problems with the transmission were being covered under the remainder of his 5-year, 60,000 mile powertrain warranty. But the vehicle itself was more than 4 years old. So in New York, we couldn't bring a breach of warranty claim because the vehicle was too old. And he didn't have a used car lemon law claim because the problem was being covered by the factory warranty. So the poor guy was left with no recourse. There wasn't anything really that we could do. I mean, we recommend, calling customer care, seeing what they can do for you. If they can help you, go to the dealer, be like, listen, you guys sold me this car. What can you do to make it right? But legally, we couldn't bring a case for him because he didn't qualify under either of them. He fell into this weird middle area where we're time barred from bringing a claim and we can't use the used car lemon law because it wasn't covered under the factory warranty. So I felt bad. That's tough, and that's what I think is really difficult when it comes to these cases, because mainly the law looks at, okay, who's paying for the repairs, right? So whomever's paying for it is the person that's ultimately responsible. So that's why, even though you may qualify under the used car lemon law because you can tick all the boxes, if the manufacturer is the one that's footing the bill and paying for all the repairs, the dealership is off the hook. And that, can be really disappointing to some people, which makes sense, right? I mean, I would be frustrated too when it comes to kind of being stuck in that middle area, that gray zone where there's not much that can be done to help you. So yeah, it's a very frustrating process because there's not really much that you can do in that situation. What we usually recommend is maybe trying to contact an auto fraud attorney. So there are still claims that you can bring against the dealership for used cars, but usually you have to show some sort of fraud or something like that on their part. And Courtney, I'll let you talk about the fraud and, what a high threshold that is for bringing an auto fraud claim against the dealership. But, sometimes that's kind of all you can do.
Yeah, it is a really high threshold, and it's kind of few and far between the people who can recover for it. But when you can, it's great. And honestly, it usually lets you recover more than a breach of warranty claim would enable you to recover. For instance, I had a case a while back. It was a commercial vehicle. It was an Isuzu, actually. It was a big, huge commercial truck. And our clients were using it for business, and they wanted to recover their lost wages because the vehicle had been defective and it was down for a long period of time, and they lost a lot of work, lost clients because of it. And I had been explaining that under breach of warranty, we can't get back lost wages, as we've talked about before, unfortunately. After a few months of discovery, it actually turned out that the vehicle had been submerged in water on the dealership's lot before it had been sold to our clients during Hurricane Sandy. This was years ago. Turns out the dealership knew about it, lied to our clients about it to induce him into selling it, and eventually sold it to him. He purchased it, relying upon the fact that it had not been submerged in water. So we were able to refer him to a fraud attorney. He ended up recovering a lot of money under a fraud claim, and honestly, a lot more than he would have been able to get back under breach of warranty. So in his case, it really worked out because he was able to show that the dealership knew that the vehicle had been damaged, lied to him, and he was induced into purchasing the vehicle based upon that lie. It is kind of the rare client who can show that, though. Negligence on the part of the dealer, unfortunately, isn't generally something you're going to be able to recover for. They were just wrong about what they thought the issue was. They tried to repair it properly, but they failed. Usually not something you can recover for against the dealership. You really have to be able to show that they knew it was defective, lied to you about it, and you relied upon that lie.
Right. The threshold for fraud is you have to show through clear and convincing evidence that they knew that they were defrauding you. So that's a really high threshold. For most lemon law and breach of warranty claims, you just have to show through what's called the preponderance of the evidence, which means if you had two scales, right, one for the defense, one for the plaintiff, the scales just sort of have to tip in one side or the other. So wherever you think most likely is the one, telling the truth or who's right in this situation, they're the ones that need to be successful. Whereas under fraud, you have to show through clear and convincing evidence. You have to be able to say, oh yeah, they knew what they were doing and they defrauded this person, which is really, really hard to show. But we have a lot of clients calling in too saying, well, listen, my vehicle was sold to me with a CPO warranty or a certified pre-owned warranty. And I don't practice auto fraud. Courtney, I know you and I have brought some negligence claims against the dealer in different situations, not necessarily a used car situation. But my understanding in talking with auto fraud attorneys is that those CPO warranties don't really mean much, and you can't really bring a claim on them. It's just some multi-point inspection that they did on the vehicle, and that's about it. It's not any sort of a warranty or a guarantee. It's just some fancy label that they can put on these vehicles to make it seem like there's a lot more behind it than there actually is.
Yeah, and it's tough because a lot of times clients will say to us, but my vehicle was CPO, as if, that really means something, and that really holds the dealership or the manufacturer to a higher threshold. And unfortunately, it really doesn't. I mean, it might give you a little more reassurance when you're purchasing the vehicle that it did go through some quality control checks and they did, check on X, Y, and Z. But unfortunately, if a problem does arise, it's really not going to do a whole lot for you.
Yeah, it's tough. And it can be really hard to pin these dealerships down too. I mean, I've handled a couple used car lemon law claims in New York and New Jersey, both of which were very strong lemon law cases because the threshold is strong. It's really high. It's hard to pin these dealerships. It's hard to show that they knew something or, that they didn't handle the situation properly or even to get these, repair orders and things like that to be able to keep them on the hook for these issues. And I even had it that when we did file a case against them, their attorney didn't respond. It was crazy. And it just kind of adds to the level of difficulty when dealing with these dealerships, and that it can be really tough. They can evade you. They can, do everything they can to they're like a worm on a hook, right? And trying to avoid any sort of liability for these vehicles. And the law also can make it difficult to really pin them as well. But I did have recently, so I had a consumer call us in New York. They had purchased a Nissan vehicle, I believe, but it was from a different dealership, a different manufacturer's dealer. And they called in and looking for help because they had a claim started with the Attorney General's office. So that's the other thing that's a little different about these used car lemon law claims is that you usually go through the Attorney General's office for them. You can file the civil suit too, but you can bring your own case in front of the AG's office for these cases if you need to. And so that's what she did. And she had a hearing coming up in a month. And based on us talking with her, she was still under the factory warranty. So we didn't think that she was going to be successful at the Attorney General's office because we were like, listen, the issues ultimately were covered under the original factory warranty, right? And so as we're digging and talking and discussing the issue more. So what happened was she had a transmission issue that the dealership that she bought the vehicle from tried to fix on their own first. So she actually ended up having multiple visits to that dealership for repair that the dealership attempted to fix on their own before sending her to a Nissan dealer that was like, oh, you need a new transmission, but you're covered under warranty, so we'll replace it for you. So ultimately, I was like, actually, I think you do have a used car lemon law claim because they kind of put themselves out there. They put themselves on the hook by performing these repairs and by kind of taking the onus on them when they should have said to her, listen, you still have your factory warranty. Go to X, Y, and Z dealer for them to repair it. We're not responsible at this point. But they made themselves responsible by performing these repairs. Or at least I think so. She still has, I told her to call me back. I was like, I really want to know how the AG's office handles this because when ultimately the defect is something that's covered under warranty in the end, does that sort of erase everything that happened before with the selling dealership or are they still on the hook? So hopefully we'll find out at some point soon because I am curious to see what happens there. But when it comes to most used car cases, we usually can help, but it would just be mainly a breach of warranty case, right? It's usually multiple visits and you get a percentage of your purchase price back. And Courtney, I'll let you talk about, because some people say, well, listen, that's all fine and good, but if I go sell this vehicle or try to trade it in now, it's branded. They're going to know that there's something wrong because I went through the lemon law process, which is a question that we get a lot. So I'll let you explain that.
Yeah, we do get that question a lot. And it's a really good thought. And it's really good forward thinking on the part of our clients. But it's actually not true, luckily. The only time a vehicle is branded as a lemon, meaning it is on the title of the vehicle that this vehicle is a lemon, is when they are buying it back from you under the lemon law, in which case it's a moot point. It doesn't matter because they're taking the vehicle back from you. When you recover under a breach of warranty theory and you're getting what's called a cash and keep offer, meaning they're giving you cash, you're keeping the vehicle is not branded as a lemon. You still have a clean title. Nothing goes on the title or the Carfax concerning this legal claim. If someone pulls up the Carfax, would they be able to see that you went to the dealership and you had some repairs done at the dealership? Of course, there's nothing we can do about the repair history being on Carfax, but the legal claim itself is confidential. It is not going to adversely affect your trade-in value whatsoever.
Right. And whatever's left of the warranties are still intact too. There's no negative impact really other than you are saying that you're one and done, right? You're not going to bring another lemon law breach of warranty claim against them for the same car. And then a lot of people use the money to trade it in, unfortunately, and send it off to someone else when they're left in this middle gray area where they can't get it repurchased and all we can get them is cash. So I guess for our next point, let's talk a little bit about it. This is kind of hard to do, but we'll give our best advice on how to sort of prepare yourself and arm yourself when you're going in to buy a used car. Like, what should you be doing? And I think it all comes down to the main point that Courtney and I always make, which is document, document, document. If the dealership tells you, hey, we know that there's a scratch on the side, we'll fix that for you next week. Just bring it back. Get a WEO slip. Get them to write that down. You can't just take their words for these things. You have to get it in writing so that you can show that they knew about it at the time of sale, they had agreed to repair it or fix it or whatever the case may be, so that if you run into issues down the road, you have some sort of actual documentation to show that they knew about it and they're responsible for it. And additionally, Courtney, there's so many clients that call in and we find papers that they signed that they bought it as is or things like that, and they don't understand what they signed. So I'll maybe let you talk about that a little bit and just doing your best to read, what you can.
Yeah, I know when you buy a vehicle, there's a million papers that are thrown at you. And generally, you've been at the dealership for 2+ hours. You might have kids running around screaming, and it can be a difficult process. And you're trying to just get through it quickly. But do try to pay attention, especially anything concerning a warranty. You're generally going to be given a page that says manufacturer warranty, dealer warranty, or vehicle is being sold as is. And there's one of those boxes is going to be checked. As is obviously means you are taking that vehicle as it currently is in its current state. And you're not going to have any sort of recourse if there is an issue there. So definitely make sure that you do have some sort of warranty. It's always good to have a warranty. Now, if you have to pay extra for a warranty, that may be something that you kind of need to weigh the pros and cons of. But if you are buying a used vehicle, do try to get one that's still within the manufacturer's warranty period. That's going to be a great recourse for you to have. If there's one that has 20,000 miles on it, as opposed to one a little bit cheaper that has 50,000 miles on it, it might be worth your while to pay that extra money to get the lower mileage if that means it's still within the manufacturer's warranty period, because that very well may end up being far worth the money in the long run.
Yeah, absolutely. I mean, extended warranties are not how they used to be. I feel like they used to kind of just be, a lot of people call and be like, what does it cover? I feel like I have to pay for everything. I think they're much better now. I mean, they usually have like a $50 or $100 deductible, but from my own personal experience and what I've seen, they actually do seem to be, worth their weight. They're usually a couple $1,000s, which can be tough when you're like trying to keep that monthly payment down. But when you compare it to the repair costs, I think, you're right. And another item too, so anything that you don't understand, don't let them push you. Make them explain it to you. Because I've had clients too where, fortunately, we got it repurchased, but I was looking at the finance contract and I was like, do you know that you have a balloon payment due next year for $20,000? And what that means is, so sometimes financing can be set up where you've got, 6 years of payments. You're going to make the same payment for 6 years and you're good. The car's yours at the end. And then there's other financing that can be set up where you pay for like 3 years at a certain number, and then you have a balloon payment due at the end of those 3 years to buy the vehicle, meaning whatever's left, you've got to pay that money at the end of when those 3 years expires. That's a lot of money to have to just suddenly come up with at the end of 3 years. But he kept telling me, oh no, I don't need to pay that. That's just, something that is in there that if I want to buy it at the end of 3 years, I can. And I was like, no, this is not a lease, right? A lease agreement at the end of 3 years, if you want to turn it in, you can. If you want to buy out the residual value, you can. No, this was a retail installment contract. This was a purchase agreement, and that was the balloon payment at the end. But again, by not asking all the right questions and really getting clarity on it, fortunately, the vehicle got bought back. So we avoided the whole issue. But that would have been a big problem to have to pay that money up front. Same thing with interest rates. A lot of clients don't understand their interest rates, or that they have other loan options that they can do, that they can source to help them out. So I guess like the main takeaway is just to do your best to not let them rush you and to pay attention to what you're signing and what the terms of the agreement are. And I guess like one other anecdotal thing that I'll throw in just from, again, my own personal experience is how important gap coverage is. So, for example, I had friends that purchased a vehicle and like 4 months later, they got into a really bad accident. Everybody was fine, fortunately, but they were rear-ended. Car was completely totaled. So the insurance company is just going to pay you out what the market value is for your vehicle when it's totaled. And what gap coverage does is it closes the gap between what you owe on the vehicle and what the insurance company pays you out. They didn't know that they needed to get gap coverage, right? They assumed it was like extended warranties and the dealer was just trying to sell them something extra. That gap coverage would have covered the $3,000 loss they now had because the insurance payout was $3,000 less than what they owed on it. So just anecdotally, gap coverage also really important and something that you should take note of, especially when buying a used vehicle, because the loss in value once you get off the lot is just, it's just natural. It's just going to keep happening. But I think that that's sort of like the main takeaways, right? Make sure you do your research. You know what they're saying to you. You understand the terms of the agreement and you document everything that you possibly can.
Yeah, absolutely. Especially the documentation. I can't tell you how many times we've had clients call in and say, well, the dealership promised they would fix X, Y, and Z. They said they knew about this and just to bring it back, no big deal. You don't know who you're talking to, when, who's going to be there that next time you bring the vehicle back. And even if you do get the same person, it's amazing how forgetful, we'll say, these dealership technicians can be. And that's to give them the benefit of the doubt. So absolutely get everything in writing and don't be afraid to ask questions. Don't be afraid to advocate for yourself. And if you think you're being a pain in the butt, don't worry about it. That is their job, is to make you understand. So you definitely want to understand everything. I think it's a very common thing not to understand exactly what your financing may be, especially when people are rolling negative equity into a new vehicle. So they were upside down on a loan in a previous vehicle and they just roll it into this one and think everything's great. And then we may be able to get them a buyback under the Lemon Law for this current vehicle, but they're still going to have to owe that negative equity from the previous vehicle. So just as Emma said, be very aware of what you're signing and don't be afraid to ask questions.
Where a client is like, listen, I don't understand. You told me I'm going to get my money back. They're going to buy this vehicle back for me and I'm going to get the purchase price of my truck back. And it's like, well, yes, you are. You're getting the purchase price of your, 2024 Sierra or whatever it is back, but you're not getting the leftover price for your, 2016 Yukon that you traded in on it. So you're responsible for that. They're only responsible for paying off the loan portion that's applicable to the current Lemon car. So a lot of people, like you said, they end up upside down and they actually have to owe money to get out of the vehicle because they have to pay off the loan. The manufacturer has to be able to take title to the car in order to brand it a Lemon. And you've got to pay off your financing in order for that to happen. So it can be, really tricky. And like you said, you got to pay attention to what you're agreeing to and what all is being rolled into your financing so it doesn't later, kind of come back to haunt you. But always do your research and try. So let's say you buy a used car and you're not quite sure if you qualify. You don't know if you can get any help for it. There's no harm in at least calling in and finding out, right? We have our intake line that it will happily give you a free consultation at 833-4CAR-LAW to help explain whether we're able to help or not, so that you can at least get pointed in the right direction if we can't help you. And usually that direction is an auto fraud attorney, which unfortunately they're kind of few and far between, right? They're kind of hard to find. But we do have some that we can refer you out to if you're having issues, and at least, like I said, point you in the right direction of what you want to research, what you want to look for to see if you have any recourse when you have an older vehicle that's having issues. And on that note, I think that basically kind of covers used cars and Lemon Law and how you can best protect yourself. So again, check out our website, lemonlawcar.com. There's a lot more information there to be able to help you along with your state's attorney general's office. They often have a lot of information too for used vehicles and whether the Lemon Law would apply to you or not. And with that, we thank you for listening.
Thanks, everyone.
Lemon Law Unpeeled is for informative purposes only. It is not to take the place of legal advice and does not create an attorney-client relationship between the viewers and Robison Lemon Law Group. Individual results also may vary as outcomes are determined on a case-by-case basis.